In today's digital age, protection of personal data and private information is more crucial than ever before. What is the government doing to keep the citizens' data private? Hello and welcome to UPSC Polity View. Today, let's learn about the Personal Data Protection Bill 2019. What is the Personal Data Protection Bill? The Personal Data Protection Bill 2019 or the PDP Bill 2019 was introduced to the Lok Sabha by Ravi Shankar Prasad, the Minister of Electronics and Information Technology, on December 11, 2019. This comes after more than 2 years of debate about the bill's provisions. Let's listen to what Ravi Shankar Prasad said when he introduced the bill.
Sir, I move for leave to introduce a bill to provide for protection of the privacy of individuals relating to their personal data, specify the flow and usage of personal data, create a relationship of trust between persons and entities processing the personal data, protect the rights of individuals whose personal data are processed, to create a framework for organizational and technical measures in processing of data, laying down norms for social media intermediary, cross-border transfer, accountability of entities processing personal data, remedies for unauthorized and harmful processing, and to establish a Data Protection Authority of India for the said purposes and for matters connected therewith and incidental thereto. माननीय अध्यक्ष जी,
आपकी कमेटी आपको तो लंबी डिस्कस करना है इस।
अच्छा अब नो नोटिस दिया। माननीय अध्यक्ष जी, मैंने इस बिल के इस सदन में जो मैंने रखा है, इस पर जितनी आपत्तियां आई हैं मैंने उनको सुना है। मैं बहुत संक्षेप में एक बात कहना चाहूंगा। मैं फिर कहूंगा, माननीय अधीर बाबू का बहुत सम्मान करता हूं, बट यू हैव नॉट बीन ब्रीफ्ड वेल टुडे, विद ग्रेटेस्ट रिस्पेक्ट टू यू। द सेम शुड बी एप्लीकेबल टू अदर्स। अच्छा, अपनी बोशन आप मुझे बोले दीजिए ना, अब मुझे बोले दीजिए। अब आगे से फिर आपका मैं नाम नहीं लूंगा, फिर आदर कम हो जाएगा। सर, व्हाट आई एम सेइंग इज,
आगे से आप व्यवस्था करना, आप आसन से बात करना, इनसे बात ही मत करना।
ओके सर, आई वुड लाइक टू वेरी रेस्पेक्टफुली कन्वे टू दिस हाउस that the members are right and the Supreme Court had held that privacy is a fundamental right. But the Supreme Court has also added and a corrupt person has no right of privacy. The second thing is, to Saugat Babu, with greatest respect to you, the Supreme Court in the Aadhaar case itself has emphasized that we must come with a data protection law. Therefore, there is a mandate of Supreme Court also that we must come with a data protection law. आपनी बोशन आपनी. Sir, the second thing which is very important to be noted is, sir, we have not come with this bill suddenly. We set up a committee headed by a very distinguished retired Supreme Court Judge, Judge Sri Krishna. They had set up a member committee also, sir. They had the widest consultation in the entire country. 2,000 recommendations came. Thereafter we discussed, we have come here. Sir, what is the essence of this? Because a lot of things have been said on surveillance. One is a data principle. Who is a data principle? The individual whose personal data is under question. Second is data fiduciary. And the architecture of the bill is, without consent of the individual, if his data is taken, he will suffer penalty. The second is, if you misuse the data beyond the permissible consent, you will suffer consequences. And we have given provision of penalty of crores of rupees on all the persons. Therefore, by this data protection, we are safeguarding the rights of Indians. I would like to convey with the greatest of respect, sir. But I too take this point, sir. India's digital economy is rising. We have got 130 crore population, 121 crore mobile phone. We generate a lot of data, but a lot of data is also important for development of economy. And sir, we have also making a provision that anonymized data must be available for policy making, for innovation, for further things. And one thing I would like to convey to this honorable house, sir, that we have decided data into 3 categories. One is critical data. Critical data is what the government will notify from time to time. sensitive data, your income, your medical record, your sexual preferences, whole lot of things, they are sensitive data. Critical data cannot go out of India at all. Sensitive data shall go out of India only with the consent of the individual and with the approval of the authority. Therefore, sir, what about surveillance? Completely wrong, unsustainable, malicious, misleading. What we are doing is we are protecting the privacy of India's, उनकी निजता की रक्षा कर रहे हैं, उनकी डेटा की रक्षा कर रहे हैं और उनके अनुमति सहमति के बिना कोई भी नहीं ले सकता, वरना करोड़ों का फाइन लगेगा। तो सर हम इतनी बड़ी चीज लेकर के आ रहे हैं चर्चा के बाद, लेकिन सर मैं एक बात, इस बात को मैं मानता हूं कि चूंकि ये विषय संवेदनशील है और पूरी दुनिया भी भारत के डेटा प्रोटेक्शन लॉ की प्रतीक्षा कर रही है, तो भले ही इसके बनने के समय में बहुत चर्चा हुई है, हम चाहते हैं संसद की समितियों की भी इसकी चर्चा होनी चाहिए। ये हमारी सरकार का मानस है। तो सर हमने एक बात फैसला किया है, हम कल प्रस्ताव लेकर के आएंगे कि दोनों सदनों की सेलेक्ट कमेटी, ज्वाइंट सेलेक्ट कमेटी सर इसको विचार करे सर, वो हम लेकर के आएंगे सर। और हम चाहेंगे दोनों सदनों की, you are the chairman, you cannot speak in your calls. Mr. Shashi Tharoor, the chairman sir, just a minute. Mr. Shashi Tharoor is the chairman of the committee, he should not advocate his own cause. सर मैं क्या, अच्छा एक मिनट प्लीज सर, हमारा कहना है सर कि ये डाटा प्रोटेक्शन लॉ बहुत महत्वपूर्ण लॉ है और ज्वाइंट सेलेक्ट कमेटी दोनों हाउसेस की, जिसमें सभी सदनों के लोग उपस्थित रहेंगे, सर मुझे बोलने दे, सर मुझे बोलने दे। Sir, standing committee scope is well known. I don't want to question. The standing committee has do a lot of work. This joint select committee will be dedicated only and only for data protection law. और हम चाहते हैं सर, इसका प्रस्ताव लेकर के कल हम आएंगे सर। हम चाहते हैं अगले बजट सेशन के पहले ये तैयार हो जाए सर। इसके लिए डेडिकेटेड रूप से, अरे भाई आपके लोग भी रहेंगे, ना जस्ट मिनट, और दोनों हाउस के लोग रहेंगे। तो सर हमारा ऐसा मत है सर, चर्चा भी किया है, हम एक ज्वाइंट सेलेक्ट कमेटी को लेकर के आएंगे प्रस्ताव सर, और इस पूरे डेटा प्रोटेक्शन लॉ का विस्तारित विवेचन हो सर, ये हमारी आकांक्षा है। लेट the parliamentary process examine this in the most detailed manner possible, sir. And I think the select committee will have good numbers from opposition of this house and that house.
As of March 2020, the bill is being analyzed by a Joint Parliamentary Committee or JPC in consultation with industry experts and stakeholders. The JPC, which was established in December 2019, is headed by the BJP Member of Parliament MP Meenakshi Lekhi. While the JPC was tasked with a short deadline to finalize their report before the budget session of 2020, it has sought more time. The JPC report is expected to be submitted by the second week of the monsoon session of the Indian Parliament. The bill outlines mechanisms for the protection of sensitive personal data and proposes the establishment of a new independent regulatory authority called the Data Protection Authority or DPA. In addition, the 2019 bill has key provisions that were not in the 2018 draft bill, such as that the central government can exempt any government agency from the bill and an individual's right to erasure, also known as the right to be forgotten. Like many data protection acts, the bill's implications reach beyond India and could impact any organization that does business in India. India, thanks to its population size, gross domestic product, and growing number of internet users, has a unique opportunity to shape global privacy law, much like the European Union has done with GDPR. With that said, the bill has drawn criticism inside and outside of India for Orwellian, protectionist, and authoritarian-leaning provisions. Others have said the bill does not do enough to protect an individual's privacy. Let's see why was the Personal Data Protection Bill 2019 introduced. In August 2017, the 9-judge bench of the Supreme Court of India affirmed the right to privacy in the K.S. Puttaswamy vs. the Union of India 2017 right to privacy case. The court cited the right to life and personal liberty under Article 21 of India's Constitution. During the case, the Indian government set up a committee of experts chaired by Justice B.N. Srikrishna to examine various issues related to data protection in India. After public consultation of the white paper, the committee submitted a draft personal data protection bill and an accompanying report titled A Free and Fair Digital Economy, Protecting Privacy, Empowering Indians to the Ministry of Electronics and Information Technology in July 2018. The Personal Data Protection Bill 2019 is based on recommendations from the expert committee and suggestions received from stakeholders inside and outside of the central government. Let's learn about the purpose of the Personal Data Protection Bill 2019. The bill opens with its aim to provide for protection of the privacy of individuals relating to their personal data, specify the flow and usage of personal data, create a relationship of trust between persons and entities processing the personal data, protect the fundamental rights of individuals whose personal data are processed, to create a framework for organizational and technical measures in processing of data, laying down norms for social media intermediary, cross-border transfer, accountability of entities processing personal data, remedies for unauthorized and harmful processing, and to establish a Data Protection Authority of India for the said purposes and for matters connected there with or incidental thereto. It goes on to outline 3 key points. Number 1, the right to privacy is a fundamental right and it is necessary to protect personal data as an essential facet of informational privacy. Number 2, the growth of the digital economy has expanded the use of data as a critical means of communication between persons. Number 3, it is necessary to create a collective culture that fosters a free and fair digital economy, respecting the information privacy of individuals, and ensuring empowerment, progress, and innovation through digital governance and inclusion, and for matters connected therewith or incidental thereto. As mentioned before, the bill was developed through continued engagement and consultation with a host of stakeholders, including India's law enforcement who want access to US stored data during investigations concerning national security, as well as its aversion to data colonialism of large Western technology firms like Google and Facebook. The bill proposes to supersede the Information Technology Act 2000, Section 43A, by deleting the provisions related to compensation payable by companies for data breaches and data privacy failures. Let's learn about the contents of the Personal Data Protection Bill 2019. Many of the consent-related provisions in the Personal Data Protection Bill are akin to those found in the European Union's General Data Protection Regulation, or GDPR. According to the bill, data fiduciaries and data processors must obtain consent from data principals prior to processing their data. Data fiduciaries are any person, including the state, a company, any juristic entity, or any individual who alone or in conjunction with other determines the purpose and means of processing of personal data. Similarly, data processors are any person, including the state, a company, any juristic entity or individual who processes personal data on behalf of a data fiduciary. Data collectors are also subject to new reporting requirements, such as requiring parental or guardian consent for the collection of data belonging to children. The bill also provides right to data principals, those are data subjects whose data is being collected. Should the bill come into effect, data fiduciaries and data processors will have to: number 1, notify data principals about their data collection. Number 2, seek consent prior to processing data about the data subject. Number 3, collect and store evidence that a notice was given and consent was received. Number 4, allow consumers to withdraw consent as well as access, correct, and erase their data. Number 5, Allow consumers to transfer their data, including any inferences made by businesses on such data to other businesses. And number 6, make organizational changes to protect data, such as by following privacy by design principles and creating security safeguards. The bill also requires that all sensitive personal data be stored in India and that critical personal data not be transferred out of India. This has been criticized as protectionist as it will distort market-driven decisions and force companies to use local data storage service providers. The DPA can deem a data fiduciary or class of data fiduciaries as significant data fiduciaries based on: number 1, the volume of personal data processed; number 2, the sensitivity of personal data processed; number 3, turnover of the data fiduciary; number 4, risk of harm by processing by the data fiduciary; number 5, use of new technologies for processing; and number 6, any other factor causing harm from such processing. Significant data fiduciaries must carry out additional duties such as data audits and the appointment of data protection officers. The bill also has breach notification requirements. Data fiduciaries must notify the DPA of a data breach as soon as possible if it is likely to cause harm to any data principal. The DPA can also direct the data fiduciary to post about the breach on its website or may post on its own website. That said, the bill does have a number of exceptions for when data fiduciaries do not have to obtain consent to collect personal information about Indian citizens. For instance, there are consent exemptions for the state or other entities complying with court orders, enforcing the law, providing public benefits or services, and treating medical emergencies. There are other reasonable purpose exemptions for situations like whistleblowing, mergers and acquisitions, credit scoring, and the operation of search engines. Finally, the bill includes rules about non-personal data. Under the bill, the government can require any business to share valuable non-personal data such as aggregated mobility data collected by Google Maps or Uber with the government. So what is considered personal data in the Personal Data Protection Bill 2019? Data can be broadly classified into two types, sensitive and non-sensitive data. Due to the introduction of general data protection laws globally, more and more personal data is now considered sensitive. Personal data in the Personal Data Protection Bill 2019 is any such data that relates to characteristics, traits, or attributes that could be used to identify an individual. In contrast, non-personal data includes aggregated data that cannot identify an individual. For example, an individual's location would constitute personal data, while information derived from thousands of individual locations such as data to analyze traffic flows is not considered personal data. In addition to the above definition, the bill makes further distinction for sensitive personal data, which is financial data, health data, official identifier, sex life, sexual orientation, biometric data, genetic data, transgender status, intersex status, caste or tribe, and religious or political beliefs. So currently, how is personal data regulated in India? The usage and transfer of personal data are currently regulated by the Information Technology Rules 2011 under the Information Technology Act 2000. Under the current rules, the processing of personal data means companies can be held liable and must compensate impacted individuals if poor data security leads to the exposure of sensitive data. The reason the bill has been introduced is because the government believes the pace of development of the digital economy has caused existing regulation to become incomplete. For example, the current definition of sensitive personal data is narrow and some of its provisions can be overridden by a contact. In addition, the Information Technology Act only applies to companies and not the Indian government itself. Who will have to comply with the Personal Data Protection Bill 2019? The bill imposes data protection requirements on most businesses operating in India. The bill targets not only technology e-commerce and social media companies, but also brick and mortar, real estate, hospital and pharmaceutical companies. In addition, it also governs foreign companies if they deal with the personal data of individuals in India. This is akin to other general data protection regulations like GDPR, PIPEDA, CCPA, the SHIELD Act and FIPA. The only exempt are small entities like retailers who collect information manually and meet other conditions to be specified by the DPA. What are the penalties for non-compliance with the Personal Data Protection Bill? The bill gives the DPA the power to fine any business that does not comply with the bill or regulations made by the DPA or Indian government. The maximum penalty that can be imposed is 150 million Indian rupees or 2.1 million US dollars or 4% of the global turnover of the firm for the previous financial year. What are some of the criticisms of the Personal Data Protection Bill 2019? The biggest concern about the bill among academics and activists is the exemptions granted to the government. Section 35 states that exemptions can be made to collection rules, reporting requirements, and other requirements whenever the government feels it necessary or expedient in the interests of sovereignty and integrity of India, national security, friendly relations with foreign states, and public order. Justice B. N. Sri Krishna, a former judge of the Supreme Court of India, has said that the bill could turn India into an Orwellian state. In an interview with the Economic Times, Sri Krishna said, "They have removed the safeguards that is most dangerous. The government can at any time access private data or government agency data on grounds of sovereignty or public order. This has dangerous implications." In The Hindu, Apar Gupta, executive director of the Internet Freedom Foundation, said, "Privacy is mentioned just once in this voluminous document, 49 mentions of security and 56 mentions of technology." And Foreign Affairs warns of India's growing surveillance state with new technologies that threaten freedoms in the world's largest democracy. Thank you very much for listening to this discussion on the Privacy Protection Bill 2019. For more such discussions, get the UPSC Practice app from the App Store.